Yes, Mr. Anderson.
Thank you, my Lord. My Lord, we had just been looking at the judgment in A and the changes the Secretary of State made to the policy in relation to eligibility for indefinite leave to remain on domestic violence grounds in light of the decision in A. And just pausing there, again adopting the judge's analysis of the court below, on his analysis there was then no analogous comparator in play at that point in time between the claimant and those who were potentially eligible for indefinite leave to remain or therefore under the destitute domestic violence concession. The final amendment then to the scope of indefinite leave to remain for victims of domestic violence came in December 2020 with the amendments in connection with the EU settlement scheme. Since effectively the mechanism for enabling the spouses or partners of persons granted pre-settled status under that scheme was introduced through Appendix FM, and the provisions in relation to indefinite leave for victims of domestic violence were amended to allow such spouse or partner to benefit from that. And that's covered at paragraphs 17 to 18 of the statement of Nick Wood, which is in the supplementary bundle at page 270. So if I can just briefly turn that up. He explains at paragraph 18, in a very brief summary, pre-settled status being a form of permission granted to individuals who would have qualified for settled status under the EU settlement scheme, but for the fact that they hadn't been resident for the required 5-year period, and effectively enables them to top up the length of their residency within the UK as a route to then applying for settlement under the EU settlement scheme. And then at paragraph 20, he notes that that cohort is unique in terms of the obligations under the withdrawal agreement, and that those on that route have an expectation of settlement. And so on the analysis adopted by the court below, and one says the question might be, well, what changed as a consequence of that amendment to the scope of the policy in relation to victims of domestic violence that could change the position in relation to those in the claimant's cohort? And that requires us to consider in a bit more detail the differences between persons who are granted limited leave under Tier 2 and persons who are granted pre-settled status under the EU settlement scheme. I think the most convenient way of dealing with this may be by reference to my skeleton argument, if that's okay. The replacement skeleton is in the same terms as the original skeleton. It's just that there are some references to the page in the bundle. But it's really from paragraphs 31 onwards that I address this. So the first point to note about Tier 2 is that it's a heading that covers a number of different categories, including the intra-company transfer migrants, the general migrants, and then Minister of Religion and Sportsperson migrants, with some differences in relation to the treatment of each of them. First of all, paragraphs 32 to 35, I address the position of intra-company migrants. I think my learned friend accepts that so far as that group are concerned, and it's also a point that's noted in passing in Mr. Justice Kerr's judgment, that group weren't on any route that could lead to settlement. That is to say, accruing however many years on that route didn't in itself enable somebody to make an application for indefinite leave to remain, and nor at the time could they simply switch into another route and then have their leave taken into account. and we'll come on in due course to the application Secretary Singh makes in relation to the facts of this case. The second category, and the category that was focused on below, was that of the Tier 2 general migrant, which is set out in paragraphs 36 onwards. And it's set out in paragraph 245H onwards of the immigration rules, which appear in tab 20 of the authorities bundle. But it may be as convenient to take it from the skeleton argument for present purposes. So effectively, paragraph 245H of the rules explains the purpose of the Tier 2 routes, that being to enable UK employers to recruit workers from outside the EEA to fill vacancies that can't be filled by British or EEA workers, and that of course being because at the time this was still during the UK's membership of the European Union, so such workers didn't need leave to remain. Paragraph 245 HCD provided that entry would be subject to a number of conditions, including a no recourse to public funds condition, and conditions prohibiting employment other than working in the employment that the certificate of sponsorship related to. And there were similar requirements where the leave was leave to remain rather than leave to enter. And then over the page at paragraph 40, paragraph 245HF set out the requirements for indefinite leave to remain as a Tier 2 general migrant. So that included that a migrant not fall for refusal under general grounds for refusal in terms of character and conduct and such. It also required that the sponsor who'd issued their certificate of sponsorship that led to their last grant of leave still hold a sponsorship license, and certify that they still required the applicant for the employment in question for the foreseeable future, and that the salary payable for the foreseeable future would exceed the minimum thresholds. In addition to which, an applicant for indefinite leave to remain would also have to demonstrate that they had sufficient knowledge of the English language and sufficient knowledge about life in the UK. Supposing there, in addition to satisfying the requirement that they have had their period of limited leave as a Tier 2 migrant, they would also have to satisfy those conditions that look to the future, as well as conditions in relation to the English language and knowledge of life in the UK. So whilst it may be a path to settlement in the sense, or a route to settlement, or whatever similar form of words might be used, in the sense that a person on Tier 2 leave could in principle make an application for indefinite leave to remain at the end of it, there would be no guarantee of the success of that application. Furthermore, as set out in paragraph 41 of the skeleton argument, the grant of Tier 2 leave is subject to conditions and could be revoked in the event of a breach of those conditions. And that would include things such as somebody failing to start work with their sponsor, or ceasing to work with their sponsor, or their sponsor seeking to hold a license or transferring their business to somebody who didn't hold a license, or various changes being made to the employment that the individual had, for example, in relation to the level of skill that it was said to require, or salary, or whether or not a job was on the shortage occupation list. So there are a number of different circumstances in which a person granted limited leave under Tier 2 could have that leave curtailed or revoked. Some of them entirely outside that individual's control, and reflecting in some respects the ordinary vicissitudes of life in terms of things like whether or not somebody maintains their job or changes in economic conditions and such. That has to be contrasted in my submission with a position under the EU settlement scheme, whereby an individual could be granted pre-settled status without satisfying such stringent requirements, and would be granted indefinite leave to remain without satisfying such stringent requirements. And I've summarised that at paragraphs 46 onwards of the skeleton argument. Amongst other things, there are no particular conditions with regards to employment, let alone employment at a particular place or with a particular employer or at a particular skill or particular level of remuneration, nor was a grant of indefinite leave subject or conditional to somebody certifying that there was the prospect of such work in the future, nor was there any requirement to show English language skills or knowledge of life in the UK. Furthermore, those granted limited leave in the form of pre-settled status also benefited from more generous treatment in the event of certain of the general grounds for curtailment. So, for example, in relation to criminality, as explained in paragraph 52 of the skeleton argument, paragraph 53.
Can we just go back for a moment? Forgive me, Mr. Anderson. Just looking at your paragraph 48, I'm trying to get in my mind a clear picture of the sort of person I should be thinking of when I ask myself who would qualify as having pre-settled status. So it doesn't have to be someone who is from another EU member state who was working here before the specified date. It could just be that they're here. But obviously, it's not just going to be people who came here for a holiday. There's a minimum qualification period. Is there 5 years?
Well, the 5-year period will be required to obtain settled status.
Yes.
But somebody could obtain pre-settled status even if they've not been here for a period of 5 years, which was, and the purpose of the pre-settled status was, in a sense, to enable them to top up, so that they could then satisfy the 5 years.
So could they have been here? Well, presumably they could have been here as a student. Is that right?
My lord, I believe so. Yes.
But what if they had just come here for a holiday? Would they be able to qualify for pre-settled status?
Well, I think if somebody had, a person who'd just come from for a holiday wouldn't have been a person resident in the UK.
Right, so the touchstone was being resident?
Yes.
I see. But was there a minimum period of residence that they had to have, or just being resident?
My lord, I don't think there was a specified minimum period. I will see if I can ask the client just to double check that, but I don't think.
Thank you.
And I should be clear that this was broader than strictly was required under the terms of the withdrawal agreement itself, because the withdrawal agreement itself only obliged the UK to make provision for persons who were exercising treaty rights under the EU treaties in a stricter sense, whereas the EU settlement scheme went somewhat beyond that in terms of the individuals who could benefit from it.
So, Mr. Anderson, in paragraphs 46 and 47, you refer in general terms to eligibility requirements, but you don't specify what those are. So there are some eligibility requirements, but we don't quite know what they are. Is that it?
My lady, yes. Perhaps I will see if I can take an instruction in relation to that, just so that I can.
Sure. Thank you.
Fill you in on that.
Have we got Appendix EU to the immigration rules in the bundle?
My lord, we've got part of it. We don't have all of it. We've got paragraphs 11 to 14, I think, and that appears in the authorities bundle.
Understood. Well, that may suffice at least to tell us what some of the eligibility requirements were. But I think we have a flavour. Your essential point, as I understand it, is that very importantly, this is not confined, for example, to where an employer certifies, I have a vacancy which I cannot fill using the local labour force, and that's why this person is permitted to come into this country.
Exactly.
And I think, on the basis of what you've told us, and that condition would have to continue to be fulfilled were they to apply for ILR, is that right?
Well, at the point at which they apply for ILR,
Yeah.
the Tier 2 worker, their sponsor has to certify that they
those things are the
continue to
case.
be. Of course, once they've been granted ILR, it doesn't follow that if
So the
something
things
unexpected happens and the job, the business goes bust, as it were, their ILR can't then be revoked on that
right, so
basis.
okay,
But it is a condition that at the time they apply for it.
it's certified.
Yes.
Yeah.
But all of that in my submission goes to show that it's a much less precarious status than is the status of somebody under a Tier 2 visa. And of course the purpose, and in a sense that the clue in this respect is in the name, is that it creates a scheme for settlement and a status of pre-settlement for those whose period of residence fell short.
And it's also, as I understand it, a closed category.
My lord, yes, and that's one of the other points that we rely upon, because if one were to view it from the perspective of saying, well, there was a pure policy, as it were, in respect of those who were the spouses or partners of British citizens or persons settled here, which was then extended somewhat by the refugee case, and has also been extended somewhat in the EU pre-settled status case, the extent of that latter extension is quite limited, because it's a closed category in terms of numbers and also in terms of time, in the sense that applications for status had to be made by a particular date. I don't have the date at the top of my head, but subject to a good reason exception, individuals had to make their applications for pre-settled status, and once that ceases to be possible, as it were, the category can't grow. Which is also relevant in terms of if one were to be asking, has the Secretary of State diluted, as it were, her policy in such a way that now it's fundamentally different from what its origins were? And our submission would be, well, no, it isn't, because this is a limited, bounded exception. And in any event, it comes close to the settlement pole rather than the...
Yeah. I understand that. Do you also make a submission that this is at the sort of what sometimes in the case law is called high governmental policy? In other words, this was the product of the negotiations which led to various treaties being formed between the UK and the EU, which govern our departure from the Union.
My lord, yes. It's not strict, but because it goes beyond what those treaties require, as it were, it's not strictly a case of saying this was part of an international agreement and so we're in the territory of it quite being a sort of conduct of foreign relations point. But it is a matter of high policy in the sense that obviously treatment of that cohort of people in it was a matter of significant...
Yes, that's really what I was getting at, if it's the correct way of looking at it. In other words, it might be said that even if not strictly required as a matter of international treaty law, nevertheless, we all lived through that period in this country's history. There was a lot going on, no doubt a lot of toing and froing.
Yes.
Concessions were no doubt made sometimes by the EU, sometimes by the UK, eventually in the hope, no doubt, that there would be benefits, socio-economic and other benefits for each side.
Yes, and that is relevant when it comes to considering as it were, the comparator that the judge was analysing the things through being the person with that status. You can't divorce the consideration of the scope of that and the extent to which that affects the general policy in relation to indefinitely for victims of domestic violence without seeing it in that context.
Right.
And so, taking those matters together then, and this, in a sense, then goes to your point as to whether these are looked at under analytic circumstances or under justification. But the respondents' position is that they do show that these are situations that aren't really analogous, because the differences between them are such that, in a sense, one doesn't need to ask the question or go on to ask the question, well, why is there, or what is the justification for there being a difference in treatment? The justification, in a sense, flows out of these very different aspects of the objective situations that these people were in.
Mr. Anderson, that might be thought, sorry to interrupt you, to support my lordship, my Lord Justice Singh's point that he was making earlier about the close link between the analogous situation analysis and the justification
Yes.
analysis.
And that you sometimes can't answer the question of analogy until you've concluded the justification.
Yes.
In a sense, that's what you've just done.
My lord, yes. And then it may be a matter of thinking about what the best, in a particular case, maybe at the end of the, you then think, well, how is this best expressed by saying you're in a different situation from that person, or is this best expressed in saying you're in a sufficiently close situation, but here are the reasons why you should be treated differently, and that may, that will be different in different cases. But I certainly don't take any issue at all with the submission that these are not. The questions are intended as an aid to analysis rather than as a straitjacket. If I can then just briefly then turn though to justification in terms of the general principles, I don't think there's much between the parties in relation to those, but there are a few points I think to pick up on. I think first of all, it's common ground, I think, that the status relied upon is immigration status, and that immigration status is not a suspect status in the way that...
Yep. Can I just ask you to pause on that? I mean, you're quite right, and that may be the end of this particular question, but it's just occurred to me as you were going through your last set of submissions that actually the EUSS could be said, on one view, to draw a distinction between people on the grounds of nationality.
Yes.
Because you have to be an EAA national to qualify, whereas a national of India will not qualify by definition. So is there anything in that point?
Well, I suppose the first thing I would say in relation to that is if one were to adopt that analysis, then I think that might be closer to it might be closer to an indirect discrimination analysis than a direct discrimination analysis would be the first point. But second, I think it's interesting that in Ponomaryov, which is in the core authorities bundle at tab 8, the Strasbourg court noted the special status that the EU has as a legal order, and that's at paragraph 54.
So, sorry, which tab is it?
Oh, sorry, this is tab 8.
Thank you very much. There were domestic cases like this as well, a long time ago. I can remember, I think there was a national from a Middle Eastern country who tried to argue that they were being discriminated against because EU nationals were treated more favourably by our immigration system. And the domestic court said, yes, that's the whole point of being in the EU.
Yes. Well, and that would, to a certain extent, also go back to the point, in a sense, to the high policy point, which is that states will sometimes make agreements with each other for reciprocal treatment of their citizens in particular fields, and if they do, then that may that will generally found the reason why they're then treated differently.
So sorry, which was the paragraph?
Oh, I'm sorry, Melody. It was paragraph 54.
54, thank you.
Where it notes about halfway down, it says, it may also in certain circumstances justify to differentiate between different categories of alien residing its territory. For instance, preferential treatment of nationals of member states of the EU, some of whom were exempted from school fees when Bulgaria acceded to the Union, may be said to be based on an objective and reasonable justification because the Union forms a special legal order which has moreover established its own citizenship. Now, of course, we're not part of that legal order anymore, but we are dealing with something arising out of the fact that we were part of that legal order. And it just...
Yeah. I was just going to suggest maybe one way of looking at it is that it isn't in substance discrimination on grounds of nationality, it's discrimination on grounds that relate to our former membership of the EU, which is actually a different point.
Yes, and that's why it might, there could be an argument of whether it's indirectly in the sense that it might affect one group more than another, because one group is more likely to have, but it wouldn't be a direct discrimination.
Right. But in any way, that's not how the case has been put against you.
No.
Right.
So far as the case as it has been put, I think we're agreed that we're not dealing with a suspect status. There has been some debate about whether or not we are dealing with a measure of social or economic policy or strategy such that a wide margin of appreciation should be afforded. And in my submission, that is the situation we're dealing with. Generally, the question of grant of residence permits and immigration status in my submission is a measure of social policy. At any event, when it comes to thinking or considering what the general rules should be, and I think there's some authority from that in SC at paragraph 115.2, which is in the supplementary authorities bundle. That's tab
12.
12.
Yes. 115.
Yes. And it cites Lord Reid noting that one of the general points that is usually out to say when it comes to general measures of economic or social strategy, and then amongst the citations is the grant of residence permits in Biao and Denmark.
Yes.
I don't think you need to turn Biao itself up, but it is also in the authorities bundle at tab 19.
Yeah, I've read it, and I thought it was interesting that even in that context, as I think Lord Reid observes in a different passage in SC, it all depends. That there isn't just one factor which determines the scope of the margin. Because in that case, there was actually indirect discrimination on grounds of ethnic origins. And the court eventually, the Strasbourg court, held that there was a violation of Article 14, as I understand it.
Yes.
So even though the starting point can be, oh, this is in relation to a matter of social and economic policy, like residence permits, welfare benefits, we know from gay uses, just because it concerns welfare benefits doesn't mean that there might not be a strict form of scrutiny used because the ground was nationality.
Yes.
But I think the fundamental point Lord Reid is making in SC is that there are a number of factors and they can sometimes pull in different directions. So you can't just isolate one factor, like saying, well, it's nationality, therefore it's liable to be struck down, or it's welfare benefits, therefore there's a very hands-off approach taken. It's much subtler and more complicated than that, as I understand it.
Absolutely, that's right, yes. It's a matter of identifying which are the relevant considerations that bear upon the margin scrutiny that the court should afford in a particular case. That, of course, will also depend upon the as it were, the cogency of the reasons put forward intuitively as well. But yes, there's no, as it were, shortcuts to considering what are the different factors bearing on a particular situation. But I simply make the point that in this situation, amongst the factors that bear upon the court giving a reasonably wide margin are the fact that it's in the context of immigration, and as your lordship noted as well, concerns distribution of public funds, and insofar specifically as any comparison is with the persons under the EU settlement scheme, it's got those additional elements arising out of the particular context of our former membership of the European Union and the circumstances in which that came to an end. And against that background, in my submission, there were no errors in the approach that the judge took to justification. There are really sort of 3 points that are taken against the judgment, I think. The first, the direct discrimination point, and I think the appellant submits that the judge erred by not approaching this as a case of direct discrimination. But so far as that is concerned, I mean, the first point to note is that from the point of view of an Article 14 claim, strictly speaking, the question whether discrimination is direct or indirect isn't a necessary part of the analysis at all. There is sometimes a danger in drawing some of the domestic terminology into the quite different conceptual structure of the Strasbourg terminology, because, for example, the questions of categorization of discrimination in domestic law might be determinative as to whether or not justification is possible at all, which simply isn't true in terms of the approach the Strasbourg court takes about it. But as your lordship noted in FA Sudan, it's fair to say that generally speaking, it may be said that direct discrimination will sometimes be harder to justify than indirect discrimination, because the one concerns a more direct relationship than the other does. And we take no issue with that. But in the context of the judgment, I think all that Mr. Justice Carr was doing was setting out the reasons for distinguishing this case from cases of Pegasus and Bonamario, on which the appellant relied, and in particular, as has already been noted in exchange with the court, those cases related to difference of treatment based on grounds of nationality. And in any event, factually, they're very different cases. I don't think any attempt is made to suggest that they're factually anywhere close to this particular case. So that, in my submission, didn't indicate any error of law. It was secondly suggested that the judge has identified or fixed on the wrong decision as requiring justification, and that the judge, in a sense, asked himself whether or not the Secretary of State was justified in extending the scope of the concession to the persons within the EU settlement scheme cohort, whereas the question that needs to be asked is whether the difference in treatment between those in the claimant's cohort and those in that cohort is justified.
Well, that fits into a classic Article 14 analysis. So if, for example, you were to give benefits to men, even though you didn't have to,
yes,
then cases like Abdelaziz make it clear that you then have to justify the sex discrimination.
yes.
But here, your fundamental submission is that any difference of treatment from EU-SS people is objectively justified.
Yes. And we agree it's the difference in treatment that falls to be justified. It's not some other separate measure in its own terms, but all that the the judge was doing was pointing to certain features of that measure that go to explaining why the difference is justified. In particular, its connection with the withdrawal agreement. I don't think it would be fair to say that the judge had focused on the wrong question. And then I think the third, more general ground was effectively to the effect, well, inviting this court to conclude that there was no objective justification, but in my submission, there plainly was, for the reasons that have already been canvassed.
Now, Mr. Fripp, I think, has really clarified in the oral hearing that his fundamental submission is that the rationale of the policy can no longer be said to be what it once was, which was about treating people who were citizens or permanently resident here differently from other categories. And I think he goes on to submit that once you go beyond that, then there can be people who don't have ILR and have only limited leave. But as he puts it, they're on the path to settlement, and that therefore, I think he ultimately submits that the rationale of the policy itself drives one to the conclusion that the category into which this appellant falls should also be treated in that way. In other words, that logic drives one to the conclusion that she should be given the benefit of the policy because it's no longer confined, in effect, to people who have ILR.
Yes. My lord, the difficulty with that submission, though, in my submission, is that one has to then ask, well, what are the extensions? What are the reasons for the extensions? And how far away do they take you from the original policy position? One can certainly imagine a situation in which one starts with a rule and then creates a dozen exceptions to it, and then the 13th person says, well, why don't I get an exception too? The rule's been swallowed up by the various carve-outs that there have been to it. But that isn't what's happened here. What we have here is the original position, which made a very clear demarcation between persons joining settled partners or citizen partners and everybody else, which was then amended in relation to the specific category of refugees because of certain features that are very specific to that category and don't generalise to, as Lady and Dorian drew the comparison, the sort of worker and student whole. What we've now got, additionally to that, is this time and size bound cohort, which also has a number of unique features that bring it close to the original policy intent. But the claimant is still very far from that original policy intent, because she, on the basis of the facts as we assume them to be below, was the partner of somebody who had a form of leave that could have been curtailed or revoked in a number of different circumstances, including circumstances entirely outside his control, but not entirely unpredictable. I mean, people do lose their jobs sometimes. Companies do lose their sponsor licenses. These are the sorts of things that a person contemplating a move from one country to another on a limited basis will have in their minds, inevitably. So it's very different from the situations to which the policy does extend. So whilst I don't doubt that in principle you could have cases in which the exceptions have so swallowed the rule that its original rationale no longer bites, that isn't what's happened here.
Right. To what extent does it turn on the question of whether or not the opponent has an expectation of settlement, as opposed to being on a road which may end in settlement?
Well, I suppose I'd make a couple of points in relation to that, my lord. I mean, the first is that it's important to focus on what the policy is and the categories to whom the policy applies, rather than the rationale for the policy, or to recognise that those are different things.
Yes.
There's a tendency sometimes in my submission of my friend to conflate the two.
Yes.
That is, this is the policy, and then this is the reason for the policy, to say, well, the policy is just the reason. That's not quite right. Not least for the reasons identified by Your Lordship in FA Sudan, and also I think by Mrs. Justice Leven in AM, that you may have a policy intent to help a particular cohort in a particular way, but it doesn't mean that you're logically committed to extending that as far as you possibly can. And in terms of the expectation point, I mean, in my submission, the short answer is that a person with limited leave to remain has no expectation of indefinite leave to remain at the end of it. They may have an expectation as to being able to apply, but of course, immigration rules do change over time, and those changes don't necessarily only bite, as it were, on persons whose first entry was after the change. They may apply so that it may be harder for a person to apply for indefinite leave to remain at the end of a period of limited leave than it would have been at the start. They know that the period they're actually granted is time-bound, and they know that it's subject to a raft of different conditions which they may or may not be able to fulfil. And in those circumstances to say, and that's why in my submission, generally speaking, limited leave to remain is treated as precarious for the purposes of the Part 5 of the 2002 Act. I think there was a brief reference to Rupia earlier, which came out of the submission I'd made below, which was simply that the court had concluded that for the purposes of that Act, a person's status was precarious if they didn't have some sort of settled status. Precarious didn't mean that they were here unlawfully or anything else. And there would be a certain tension between, on the one hand, having a system under which limited leave is considered as a precarious status, and on the other saying, but you've got an expectation or sufficient expectation of indefinite leave at the end of it. And there's also, on top of those points, I suppose there's a bit of a caution needed around the language as well, because if one were to think of it, at times it's been put in terms of whether there's a legitimate expectation or a reasonable expectation, but if one were to put it in public law terms, I mean, the idea that a person could bring a claim based on, to put indefinitely, based on the fact they've been granted limited leave on legitimate expectation grounds simply wouldn't get off the ground.
Sometimes, not only in public law, the law distinguishes between a mere hope and an expectation. And none of these concepts are meant to be rigid or fixed, but I think that's really what my Lord is getting at, that conceptually it can sometimes help the analysis if one understands that there's a distinction between something which, as you accept, may well, in one sense, be described as a path to settlement. And it may well lead at the end of the day to settlement. But you say that's something distinct from the person who comes here in the expectation of settling here.
Yes, my words, yes. I mean, expressing it in terms of a hope would more neatly capture what in reality the person has. Another way of thinking of it is, as Mr. Justice Carr put it in his judgment below, there's a path, but there are obstacles in the way.
And of course, it's not just, it's more than just, the rationale says, doesn't just stop at expectation. It says it in slightly different words at various points, but in paragraph 5 of Mr. Wood's statement, for example, reasonable for them to expect to have their future and their permanent home with their partner in the UK. So from the outset, they may well loosen or cut their ties with their country of origin.
Yes.
That's the, it's the rationale isn't just a reasonable expectation or expectation. It's the combination of those things.
Yes, and one can see that, if one thinks of, for somebody to say, for example, well, I decided to cut ties with my country because I came to the UK with a grant of leave for 5 years would would not be very rational in most circumstances. And of course, my lawyer friend did address in certain reasons why his client in particular may feel that she couldn't return. But if she had a well-founded fear, for example, of reprisals or that sort of thing, then there's a different route for seeking to claim, which would be to make a protection-based claim, if that were her.
And I think you would also submit that on this appeal, what the court is concerned with is the lawfulness of the policy,
Yes.
which of course can't turn on the facts of an individual case.
Yes.
Sad and sympathetic though they no doubt are.
Yes. But those are the reasons why in my submission the appeal falls to be or should be dismissed.
Right.
I've realised I've not yet turned, which I can deal with very briefly, to the application
Yes.
in relation to the
Well, I think your first, let's just see the structure of the argument. I think your first submission is that even on the basis that the judge understood the facts, the judge was correct,
yes,
the appeal should be dismissed.
yes,
But the grounds of appeal are simply not made out. And we'll have to think about that. That may be one outcome. I don't know. But I think you're about to go on to a second submission, which is that actually the factual basis on which the case proceeded below was incorrect, and that you should be given permission to adduce evidence to correct that now. Is that what you're going on to?
my lord, yes. And I can deal with this, I think, very briefly. Partly because my learned friend has very helpfully indicated in discussions that although there's a rather lengthy bundle, the unagreed evidence bundle, we are in agreement that the material within it, if it were admitted, would establish, as a matter of fact, that the appellant's partner was on a Tier 2 ICT visa at the relevant time, and it's further accepted that that wouldn't have created even a path to settlement in the sense in which we've been using it. So the premise of any submissions that are based on that simply wouldn't apply if the court were to admit the evidence in relation to that fact. As to whether the court should do that, well, if the court upholds the judgment on the basis on which it was already made, it may be that the court won't need to deal with the application at all. But in my submission, it would be, particularly in an appeal against a claim for judicial review, appropriate, where possible, to proceed on the correct factual basis. I accept that there's no good reason why this wasn't identified at an earlier stage of proceedings. And indeed, the application should probably have been made to accompany the skeleton argument filed in December, rather than, I think, when it was filed in March. I think what we hoped was that the parties might be able to come to an agreed position in relation to the facts on the basis of which the court should proceed. So there isn't a good reason for it not having been identified earlier. The factors that in my submission tell in favour, though, of proceeding on that basis are these. First of all, we're not talking about a situation in which, as it were, there is evidence to be put into the mix with other evidence about a contested factual proposition which is, in fact, at large in the real world. So this is more akin to an error as to an established material fact in my submission. Secondly, insofar as the appeal deals obviously with matters of more general importance, it's important, or at least useful, to be clear about the factual basis on which it's decided. And third, I would say, without wanting to diminish the fact that, as it were, we bear some responsibility for this error having gone unchallenged, or for this assumption having been made. I do say that this is a case in which both parties have contributed to the court proceeding on an erroneous factual basis. But to be absolutely clear, and again, just to consider my own friend in discussions, there's no suggestion at all this was in any way deliberate or anything like that.
No deception.
No, not at all. But the claim itself, as pleaded, didn't identify a particular species of Tier 2 leave, which it was said the claimant's spouse had, but did proceed to refer to being on a path that would lead to settlement after 5 years. Now, we should have challenged that assumption and picked that up. But at the same time, I would say in a claim for judicial review, if the claimant wasn't aware of the status and whether or not that status, in fact, gave rise to a path to settlement or one that was capable of, in due course, leading to an application for indefinite leave to remain, that is a matter that should have been pleaded. And of course, that's on top of what we submitted were difficulties in the pleading more generally, which you'll see we haven't sought to revisit in terms of whether or not the judge's decision to proceed to determine the claim in the way that he did was right or not. But it may be that had the particular claim in issue been identified more clearly, it may have been flushed out at an earlier stage. There was, I should say, subsequent correspondence from the claimant asking for her file, I think in June of 2022, and that should have been responded to, but wasn't. But I would simply say that was many months after the claim was issued and a few weeks before trial, after all the pleadings had been exchanged. And so it's a situation in which, in my submission, there has been an element of contribution from both parties to the fact that the court proceeded on a false assumption, and it would be better to correct that rather than not.
But can the claimant below the appellant, as she now is, have been expected to know the precise details of her husband's Tier 2 leave, particularly in circumstances where the decision which is at the heart of this claim, which is on page 115 of the bundle, doesn't specify what type of Tier 2 leave he had, because it simply refers to the last leave that was granted to her as a Tier 2 dependent.
My lady, in my submission, it isn't necessarily that the appellant should have known or been expected to know the leave that she had, but the fact that she didn't know, or if it was a fact that she didn't know, could have been stated and identified as part of the pleaded case. It's not uncommon, at least in my experience, to see claims for judicial review in which, particularly if a party doesn't have complete records, for example, they may identify that there are certain matters that are outside of their knowledge.
But the point I'm trying to make is that the decision which is challenged doesn't make any distinction between different types of Tier 2 leave. It simply says she's a Tier 2 dependent. So she might be forgiven for thinking, that's what I am.
I think my answer to that is simply that Tier 2 as a category encompasses a number of different subcategories. So it really goes more to the point at which the claimant, insofar as the claimant makes a positive assertion, I'm being the spouse of a Tier 2, or I'm a Tier 2 dependent, and as a Tier 2 dependent, I'm on a path to settlement. That isn't accurate as a matter of the rules in place, because there are different categories, some of which were and some of which weren't. And I simply say that is something that should have been picked up before the claimant positively asserted that she was on a route, or that her partner was on a route that leads to settlement, which is an assertion that was made.
It might be said that if anyone should have picked it up, that should have been the Home Office.
My Lord,
especially when proceedings are started against them.
My Lord, I mean, to be absolutely clear, I entirely accept that this is a matter that should have been picked up. So it's not a case of suggesting that it shouldn't, but I do submit that it is a matter to which, as I put it, both sides may have contributed. The claimant could have said, for example, I'm the dependent of a tier 2 migrant, and I don't know what status I have, and I don't know what that means in terms of settlement or not, but I should fall in the scope of your policy. And that would flush out the knowns and the unknowns, if that makes sense.
Does this really go to remedy in the event we allow the appeal? This point.
I'm sorry.
Does this really go to the remedy if we allow the appeal? Does this go to remedy?
Well, my lord, the appellants, as I understand it, are
You say we shouldn't allow the appeal because
Yes.
if the matter were determined on the correct factual basis, then Mr. Fripp concedes that his client, the partner of his client was not on the path to settlement.
yes,
So his argument falls away.
yes. And in a sense, that's the point, I suppose, in a sense, is insofar as if one divides it into, I suppose, thinking about the factual premises and the legal premises of the claim, if the claimant's position was that she doesn't know what form of leave she has, then I do say the claimant shouldn't positively be pleading she's on a form of leave that creates a route to settlement. Whether that's could have been addressed by saying factually, I don't know, or by recognising that there are some tier 2 routes that do and some tier 2 routes that don't.
I see all of that, but sorry, I didn't mean to interrupt you,
Sorry.
but I was just going to move on to a slightly different question, if I may, which is that we are where we are. The judge did decide the case, as he did, on the basis of the facts as they were presented to him.
Yes.
And this court has very well established rules and procedures which govern the admission of so-called fresh evidence.
Yes.
Traditionally, that's always been called the Ladden-Marshall point. Strictly speaking, the CPRs are not the same as Ladden-Marshall. But nevertheless, we still use Ladden-Marshall very often in practice to guide us on the admission of fresh evidence. Now, do you say that this qualifies for admission under Ladden-Marshall?
Well, my lord, it doesn't insofar as there isn't a good reason for why it wasn't identified earlier. And so it's a question then of considering matters in the round as to what it would be in the interest of justice to do. And the factors that I've sought to point to are why I say this falls somewhat outside perhaps the paradigmatic case in which a party seeks to produce evidence to throw into the mix with other evidence about a matter of fact that's disputed.
I understand that.
That's not really where we are here.
No, that I understand.
And also, as I say, the circumstances in which where we are, the challenge we're actually debating today, or the focus of the debate today is really very different from the claim as it was pleaded now some time ago. And I just invite the court to bear that in mind when considering what would be the appropriate course of action.
So we should allow it in because it's such a fundamental point, which is effectively would have to be conceded that it's outside the normal Ladden-Marshall framework. Is that what you say?
In the specific context of judicial review type proceedings, where there is as it were, an onus of both parties in relation to ensuring that the court is presented with all of the information that it needs to have.
Well, that's true, but the respondent, as a public authority, has a particular duty to assist the court to achieve justice.
My lord, yes, and as I indicate, I don't seek to shy away from that at all. But of course, in a sense, I make all this at the end of my argument rather than at the beginning, because
that's understood.
the argument of the case has effectively proceeded.
There is one other point I should mention, so that you can make any submissions that you wish to. As you know, in the last few years, this court and the High Court have, on a number of occasions, emphasised the need for procedural rigour in the conduct of judicial review proceedings. And that has sometimes, by some commentators, mistakenly been understood to be a criticism only of claimants. and their representatives. And I should make it clear that it's not. I've certainly been a member of a court where sometimes it's been the public authority defendant,
Yes.
which has failed to comply with some important procedural rule. And so we've marked that in some way, sometimes in costs, or it may be in an extreme case, you might refuse to admit certain evidence or a scattered argument or something of that sort. It all depends.
Yes.
But I just wanted you to be aware that we are concerned in this case about what's happened and the non-compliance with appropriate procedures on the part of the defendant, now respondent. So I just wanted you to be aware of that, so you can say anything if you wish to.
Well, I mean, my lord, I think as I said, I didn't scale an argument, but I entirely accept that it's something that should have been picked up by the respondent, addressed by the respondent at an earlier stage in the claim, and I don't think there's any, I don't think there's ever been any dispute about that. And of course, I'm aware of there's a number of cases, obviously recently in connection with aspects of respondents' duties of candour in various different contexts as well. So we have that very firmly in mind. But I do simply say that I suppose I would put it in this, that there may be cases where all of the procedural fault, for want of a better expression, lies on one side. I do say that this isn't one of those cases, and as I say, we haven't revisited, or we haven't invited on appeal the court to revisit Mr. Justice Kerr's decision to allow the claim to proceed as a challenge that is significantly broader and with a different target and different comparator than the pleaded challenge below. But the fact that the pleaded challenge below was in the form that it was, both factually and legally, means that the real issues have been somewhat obscure. Now, I don't say that that justifies or excuses failures on the respondent's side, but I do say that it would be wrong to view this case through the lens of it being, as it were, all on one side. Unless there are any other further matters.
May I just check if there are any other questions? Thank you very much.
Thank you.
Mr. Fripp, do you want to reply?
Well, I'm very grateful. Let me take the last matter first, if I may, which is the respondent's application to rely on new evidence. I don't want to labour it. I'll deal with it extremely briefly, but we strongly take issue with the proposition that there's some form of shared liability for the failure here. The appellant was a victim of domestic violence who was removed from the home by the authorities. There was no reason to expect her to have documentation with her, or indeed, if she had been in such a relationship, to be aware of the details of her status. The material the respondent seeks to rely on, inter alia, shows that her immigration decision, the critical immigration decision for her, was served to her husband's email address, not to her own. And on the history of the matter, my learned friend refers to the way the case was pleaded by Ms. Akinbolu, but if I might point to the core bundle of the JR grounds, beginning at page 135, the statement of facts begins: the claimant entered the UK in August 2017 on the PBS dependent visa, valid until date. Her husband, WP, is an Indian national who was resident in the UK as a Tier 2 migrant visa. His current status is unknown. And there could really be few stronger flags for the Secretary of State to establish the current status than the words, his current status is unknown, in para 5 of the pleading. The pleading took her status from the decision it was directed at, which described the appellant's husband as a Tier 2 migrant. After that, the Secretary of State filed the document and the witness statement of Nick Wood. The witness statement of Nick Wood, and all of this is prior to the hearing in the High Court. So the Nick Wood statement, paragraph 33, says her husband had only limited leave to remain as a skilled worker, the route formerly known as Tier 2 under the points-based system. Something relevant here is that skilled worker is, as it were, the onward descendant of Tier 2 General. It's not the descendant of Tier 2 ICT. I accept that couldn't be taken as a basis in itself, but there's an inference, the inference that would be drawn from that is that inference. In light of that, those instructing me in the N244 bundle for the appellant emailed on the 1st of June 2022, still pre-hearing.
Sorry, hold on. Where are you going now?
This is page 17 of the appellant's N244. And this is material which goes to the respondent's application to include the new evidence.
Page 17.
Page 17. It's exhibit HK1. So there's a statement of Mr. Karamdad, the solicitor, and I commend it to the court if the history in this respect is significant, but I won't retail it. But amongst the exhibits
Yes.
is the email of his predecessor, Ms. Osazua, the solicitor for the appellant, to those responsible.
What's the date of the email?
1st of June,
Right, I haven't got
2022.
that. I'm in the wrong place, I'm afraid.
I'm sorry.
I've got page 17, but it's not the email I'm looking at.
It's the first page after the statement of Harun Karamdad.
Are you right?
That's page 1 in my bundle.
Yes, I'm sorry. I had written the PDF page pagination on,
Right.
anticipating the court would have that.
Okay. 1st of June. 1st of June 22.
Yes, and
Yep.
if I might just ask the court to read numbered paragraph 3. And that's so the heading, this is further to counsel's email. I write to raise a small number of questions. It's number 3 that matters.
The immigration records regarding SWP are obviously with your client.
Yes.
Yep.
We note that in his statement, Nick Woods indicates her last period of leave was as a dependent of a Tier 2 PBS skilled worker, but it would be helpful to be able to provide the court with a full account. Could you please set out the immigration history? And then there's a chaser to that 6 days later. And the response to that, well, you look again at the witness statement of Nick Wood.
Where's the chaser?
The chaser is HK2 across the page. In the meantime, will your client be able to urgently provide their client's immigration history as requested in paragraph 3 of our email below?
Sorry, I'm not finding that.
Page 3 of the bundle, I think.
What's the date again?
6th of June?
Yeah, that's page 3. Yeah.
And the response for the respondent was that the respondent's position was expressed by the statement of Nick Wood.
Where do we see that response?
I've been looking for it in the exhibits. I don't know whether it is in the
So there's a summary of what happened in the email dated the 2nd of December 2022 on page 5, in which the appellant's solicitor says, please see attached chain of email correspondence. Appellant made it clear unaware of current status, blah, 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 sought clarification. Respondent failed to do so and instead provided a statement of Nick Wood indicating last granted T2 leave.
My lady, I'm so sorry. I think I can't go beyond that. And
Yeah, so in other words, that's the summary of what happened.
yes,
Yes.
yes. And so that's the history of the pleadings and exchanges prior to the hearing below.
Well,
And so-
that last one is after the hearing below. It's December 22.
So this is an ex post facto summary by
Yes,
the appellant solicitor
Yes.
saying this is what happened at the
The-
before the first instance hearing.
Yeah.
yes. The Nick Wood statement and the June correspondence is pre-hearing. And so we simply say that that's highly relevant insofar as the respondent may seek to escape from the application of Ladd and Marshall. It's not possible to do so on the basis that there's any form of shared responsibility. The learned friend very fairly accepts that there's nothing to indicate dishonesty on the part of the appellant or anyone connected to her. So we were responding to the information provided by the respondent, and we are also asking for better information so that the comprehensive determination of status could be determined. And in my respectful submission, this is a case where the responsibility really lies with the respondent for oversight in establishing what the status of the husband was until a very late stage, even after the respondent's notice had been filed, seemingly, in this court. And so, in my respectful submission, in a nutshell, on the application to adduce new evidence, that is miles from meeting. It's many miles from meeting the first stage of Ladd and Marshall, and on that basis, it shouldn't be admitted.
I think Mr. Anderson doesn't dispute that,
Yeah.
but he says that it would not be in the interest of justice,
Yeah.
particularly in judicial review proceedings,
Yeah.
and particularly where anything the court says may have implications which are of wider importance. He says in those circumstances it would not be right for the court to decide a point of law on a factual basis which it's conceded, as I understand it, would be wrong.
Malad, the position of the appellant is that if admitted, the new material would demonstrate to the appropriate standard that the husband has ICT.
Yeah.
We accept that. On the issue of relief and determination, the matter has been determined, the matter has been addressed both below and, as it were, in the alternative here, on the question of the case as it would affect Tier 2 brackets general. And there is an issue there are issues to determine in that respect. We respectfully submit. If the decision were to be quashed, which is the relief we seek, the principal relief we seek, then it would be for the respondent to retake that decision. And there's nothing, as we understand it, that would prevent the respondent from retaking that in the full knowledge of the material that the respondent has now tried to produce in this court at a late stage. And so we haven't asked at any stage for a mandatory order. Right. And so absent a mandatory order, the respondent would consider all relevant material known to her at the time of the reconsideration were the decision to be quashed.
That's one possibility, assuming
Yes.
that we reach the stage of remedies at all. But another possibility, I think you say, is that even if the evidence is admitted, and even if this court concludes, therefore, that no relief should be given to this particular appellant, that nevertheless the court should, in its judgment, say things on the issues of principle which have arisen, because it's well established that in public law proceedings, although a case may have become academic on its facts, that the court sometimes does think it's a useful thing to do, to pronounce upon a legal principle.
Yes.
So is that what you invite us to do?
Yes, my lad. And of course, the judge below was entirely unaware of the subsequent issue. And it has been dealt with on the basis of Tier 2. We've addressed it today on the basis of Tier 2, subject, of course, respectfully to the fact that the application is outstanding and what the court said at the start of the hearing regarding the application of the respondent. But, I mean, the gist of our case is Tier 1 of Louth and Marshall not met. This isn't a case in which there's some public interest reason to go beyond Louth and Marshall per the decision of this court in KV Sri Lanka. And there isn't a separate question as to whether this Secretary of State can change the basis of fact absent the evidence. In essence, there's a single composite question which is wrapped up with the Louth and Marshall criteria. That's in a nutshell our case. On the issues of equivalency and justification replying, I mean, there are two matters raised by inquiries of Lady Justice Elisabeth Laing. The first was the inquiry about whether the current updating of the DDVC policy is to bring it in line with the decision of the inner house of the Court of Session in A. If I can just note one curiosity of the case is that the decision in A was handed down in May of 2016, and the policy was published in February of 2018, so 18 months later. And so it's not that the decision came after the policy, it's that the policy, as it were, was written, no doubt with no intention of disrespect, but in lack of awareness of the decision that had happened 18 months before. I'm so sorry, the second point was whether the appellant should have been expected to know, and I think the court has our response on the respondent's application. I mean, she couldn't be expected to know definitively.
To know what?
To her husband's immigration status. I mean, she was frank about that. It's also in the statement that she prepared in answer to the statement of Nick Wood that she doesn't know her husband's exact immigration status. Again, pre-hearing below. It's certainly a frequent occurrence in domestic violence cases where someone is removed from the home by the authorities, that they don't have full documentation of immigration status. But, so coming to the respond on the issues on equivalency. Murad, if I can, I don't need to take the court to it, but I referred the court to your remarks in your judgment in FA Sudan earlier, and there's been reference to it in exchanges throughout. That is to, if I may paraphrase, the fact that the reasoning for the concession, the scheme, is to avoid or address, minimize the extent to which the immigration system may contribute to injustice and also that there are other ways in which the justice system addresses domestic violence. And we accept both of those statements of principle very strongly. But on the first of those, the question raised by the case is where the line is. And that line is set by the rationale. And harkening back to an exchange between my learned friend and Lord Justice Baker, the rationale is now para 23 of Nick Wood. There are different elements to that. So the reasonable expectation is a reasonable expectation to be read in light, I accept, of the sentence that follows. There's no disunion there. It's also, although there's been some reference to the policy not changing, there certainly is at one point a change in the policy. That's reflected by Nick Wood, where he refers to the policy as it was at para 5 of his witness statement, I think, and to the current policy as he understands it at para 23. Something that, in my respectful submission, is very important to the issues here is that this isn't a situation where we say our factual situation calls for us to have help within the discretionary power by the Secretary of State. The basis on which we advance this is based on matters the Secretary of State has set down as policy. First of all, in the DDVC, as elaborated by Nick Wood. Secondly, in relation to Tier 2 migrants or Tier 2 general migrants, it is the Secretary of State who, via the policy I pointed the court to in the morning, identifies those as individuals who have a status that leads to settlement. And it's quite important that the Secretary of State designates some people as having a status that leads to settlement, although they have limited leave, designates other people who have limited leave as not having a status leading to settlement. So it isn't a matter of an individual's, as it were, emotional wishes or hopes or desires. It's a matter of the designation of the form of leave they have by the Secretary of State that we rely on. So I was grateful for the chance to address those two aspects of FA Sudan in reply. On A, I'll bring the court, if I may, very briefly to A at tab 2. And into that very long paragraph again, that 66. So earlier in A, the rationale as expressed in the affidavit had been set out by the judge at para 19, page 784. The starting point for the judge is at 66, and we accept that the reasoning in that case is different from the reasoning we pressed below and that we seek to defend or advance here. We accept that at a point the approach to the case is different, but the starting point for that court, expressed by in Lady Dorian's opinion, the aim is said to be, in question is said to be, that the spouses of those settled in the UK should be treated differently from the spouses of those without status. This is, of course, at the, as it were, the knuckle of the policy, when the policy is still defined by British citizen partners and settled status partners, and by no other criterion. The rationale for doing so is that the former are likely to have a reasonable expectation of settlement in the UK, and thus to have cut or loosened their ties with the country of origin in that expectation, whereas the spouses of the latter could have no expectation, would be less likely or to cut or loosen those ties. It's true that students and workers are distinguished, but it wasn't a part of the case to consider the situation of a class of workers who were designated by the Secretary of State as being on a route to settlement. And what is, in my respectful submission, important, and what does assist the appellant, is that the starting point for Lady Dorian is the rationale. Lady Dorian attached considerable weight in passages which the court has seen to refugees as people who don't have a choice to come to the UK. There is a little bit of friction between that, giving weight to that, and the rationale of the criterion, because the rationale is much more about the situation in the UK of the individual. I mean, of course, a refugee is generally protected from expulsion either by Article 32 or by Article 33 of the Refugee Convention. But they're not, they don't have a right to any particular form of leave to remain as refugees. And indeed, refugee isn't the language in which Para 353 of the immigration rules provides for the grant of leave. You know, that's asylum on the basis of qualification as a refugee and other matters, including not having another country which they can go to where they won't be persecuted for relevant reasons. So some of the reasons for differentiation actually may have relatively less weight when you return to the core rationale as it's elaborated on behalf of the Secretary of State, most proximately by Nick Wood. That's not about being here, as it were, by choice. It's about the situation in which someone is by virtue of an immigration status and the nature of that, the incidence, as it were, of that immigration status attached by the Secretary of State. So we do have, in my respectful submission, despite the difference in the cases, some assistance from A. And A, of course, is setting out to do what the appellant, has sought to do, which is to say, well, you say this has or rather, I'm so sorry. Let me put that. Let me take that back, as it were. Whereas A was saying you have a clear line, but that clear line is not defensible. We are saying you have a line. The line has changed because of A, and because of decisions to attach the Refugee Family Reunion people and the EEA, the pre-settlement people to the policy. But the rationale continues but the rationale continues to be the centre, just as the rationale was the centre for Lady Dorian and the inner house of the Court of Session, in my respectful submission. Mr. Wood, we've had a very detailed submission today about the EUSS as comparator. For Nick Wood, in the Secretary of State's case, as set out as evidence to the court, it was really rather more basic, and it's restricted to Para 18. Some applications under the EUSS, I'm sorry, it's page 270 of the supplementary bundle,
So page 200 and
and 270 of the supplementary bundle.
Which paragraph number would you like us to look at?
Para 18.
yep.
And so this is an explanation about as the EEA people. And we accept the explanation about the EEA people. We accept that the cohort is relatively unique because it arises out of the legal and demographic consequences of Brexit. What we don't accept is that, with all respect to Nick Wood and the way the matter has been put for the respondent, is that that is decisive against us on the application of the rationale of the policy, because it was open to the Secretary of State, as it were, to break up or ignore DDVC and treat some form of domestic violence protection as inherent to specified forms of leave, which is essentially how the Secretary of State has treated the right to proceed to settlement after a period of limited leave. The Secretary of State hasn't done that. So the Secretary of State's position is not that the DDVC or the broader domestic violence scheme is some sort of pragmatic mechanism into which cases are inserted or not inserted by discretion. It's that it's a scheme with its own admission rule. And we respectfully attach ourselves to that and say if we meet the admission rule, we should be admitted. If we're not admitted, because although we meet the admission rule that said we're not, then that is the detriment. And that we say, cannot be justified because that's not about other decisions to create the EU SS people, for example, or to provide domestic violence protection to EU SS people. And it's never been the Secretary of State's position that putting the EU SS people into the DDVC or the domestic violence protection changed the rubric for those protections or the rationale. It's also important the Secretary of State could rewrite this overnight. So this is the Secretary of State's expression of the policy upon which we rely. And it's an expression of the policy that the Secretary of State has adumbrated in evidence to courts at senior levels in Scotland and in England and Wales. On the relative, on the characteristic of Tier 2, is that it's tied to employment, or it's tied to a continuation of employment by a sponsor with a sponsor license. There is scope for change, but the basic principle we of course fully accept. The if level of attachment to the territory is somehow relevant to whether you're within the rubric, actually the requirements, if the rationale is, as it were, grown out from its expression in Para 23 of Nick Wood, to include some further elements of attachment, then actually, having to have a sponsor rather than not possibly having relatively limited ties to the country is, if anything, a stronger connection. So those aspects of the Tier 2 scheme don't, in my respectful submission, bring us away from meeting the rubric, the rationale of the DDVC. And just closing on equivalency, my Lord Justice Singh asked my learned friend, well, do you say that the creation of the EUSS and the elaboration of those provisions is high government policy? And I mean, we accept that certainly it is. I mean, some of it responding to international obligations accepted within the withdrawal agreement. Some of it going beyond those obligations for no doubt valid purposes, and we're not challenging those purposes. But the key thing about the creation of the EUSS is the Secretary of State doesn't say this changed the rationale for the DDVC. If the Secretary of State had said, well, this destroys the rationale for the DDVC and it's now going to be something different, then we'd have to address that. But there's no change by the addition to the need to the reasonable expectation standard, as elaborated and read with the following sentence. That is the interest in protection to people who have come as the dependents of people who are on what I would call the path to settlement, and what the Secretary of State in the Secretary of State's Tier 2 guidance calls, leads or leading to settlement. So moving to justification, I mean, I fully accept, I've dealt with them separately for convenience, but I fully accept all that has been said, from the bench about the degree to which these two may be read together. And it is our case, effectively, that they should be read together. And they should be read together in light of the underlying rubric, which is the rationale expressed by Mr. Wood. The Lord Reid in SC, Power 115, said, in essence, it set out a much subtler approach. The effect of that subtle approach in this case is that what has to be addressed is the situation where there's a rubric that rationale that we meet because we have limited leave, but we're on the way relevantly to settlement.
Was SC cited to the trial judge?
SC was, I believe, before the trial judge. I'm not sure that there's a reference to it.
Okay, that's fine.
I'm sorry, I don't have the high court papers.
No, you've answered my question. That's fine.
So on on other issues, my lord, your lordship set out to Mr. Anderson, to my learned friend, the basis on which the case had been elaborated in oral submissions by me, and I fully accept respectfully and adopt that account of our case. And my learned friend responds in part, well, what are the extensions to the policy? Well, there was an obvious extension to the policy when it stopped being delimited by the line of settlement and British citizenship.
Yes, I think that we have that point.
Yes, but that extension is an extension on the respondent's own evidence to take in the A and Secretary of State cases. And how are they delineated? Well, we say they're delineated essentially as they're delineated in past affidavits cited in cases and by Nick Wood in his statement. my learned friend says, well, the Tier 2 status could be curtailed or revoked. Now, there isn't statistical evidence. There was statistical evidence, although there was statistical evidence in A about the rate at which refugees transferred from limited leave to indefinite leave. But there's no statistical evidence on either of the two classes that were compared by.
So what's the consequence of that?
Well, the consequence of that is that the Secretary of State isn't assisted in defending a different outcome by being able to say, well, you know, here's evidence that shows why a different outcome is justified by statistics. And it's very important, it's quite important. I don't want to spend quite a long time, and the court wouldn't, I'm sure, wouldn't grant me liberty to spend a long time delineating the various bases on which someone who has pre-settled status can be expelled or denied indefinite leave. But you know, there is in the supplementary authorities at tab 30 the start of the section from Appendix EU, Annex 3, that sets out the bases. I'm afraid my copy is incomplete. The second page isn't there, but I want to deal with this, as it were, in a broad way rather than a narrow way. What that shows you is that there are many routes by which an individual with pre-settled status doesn't have a guarantee of proceeding to settled status. There are numerous grounds on which that leave can be cancelled, curtailed, revoked. Insofar as the measure in Para 23 of Nick Wood is reasonable expectation, there's no form of status. Perhaps British citizen involves a step change.
Everything up to that point.
But everything short of that.
There's a potential hurdle in the path which
Yes.
could confound even the person with the strongest expectation.
Yes, your hurdle could be that hurdle, or that hurdle, or that hurdle.
And yet you've got not even citizenship.
Well, there's Section 40 of the Nationality
Anyway,
Act. But that I shall.
so your point is that the same point that's made against you could be made in respect of,
Yes.
in this case, EU SS.
Yes, yes. And Malad, there was a response to you by my learned friend on the question of whether the protective purpose leads to an expansion of the cohort. And it's not our case that the cohort gets expanded. The protective purpose is identified, as it were, in the rationale, and its extension is identified in the rationale. So there are obvious cases. Someone who is the spouse of a student who is subjected to extremely brutal and arbitrary domestic violence, if one can categorize behaviors within that bracket, still doesn't come within the rubric because of the abhorrent nature of the conduct to which that person is exposed. You have to have something more than being in the country and being exposed to domestic violence. The Secretary of State has set a line, and we say we're on the right side of the line, as the Secretary of State is on that line. That's our case.
Yes.
Let me. I think that addresses all of the points. If I might just have a quick look at my speaking note and consult my junior to make sure that I haven't missed anything. Unless there's anything further on which I can assist the court, those are my submissions. Thank you very much.
Thank you very much. Now, Mr. Anderson, I think the strict position is that you can't reply on the original appeal. But if there's anything which has been said in relation to your application to adduce further evidence, do you want to reply on that?
My Lord, very briefly, if I may, and I also just want to come back on 3 points on which I was going to come back in terms of instructions. The first was just to confirm that the DDVC policy will be updated to reflect the various statuses that we have been talking about as part of the general update of the policy that will be forthcoming. The second point is just in relation to pre-settled status and the conditions for that. The person had to have started living in the UK by the 31st of December 2020, which was the transition date.
Yes.
They didn't require to have been living here for any particular period of time, but there was, as it were, a continuity of residence provision so that somebody couldn't say, I'd started living here in 2018, then moved away, and I'm relying upon that. And the deadline for applications was the 30th of June 2021. Yeah. And then third, your Lordship asked whether SSC, I think, was cited before the court below, and it was. It's at paragraphs 28 and 40 of my skeleton argument, the court below.
That's very helpful.
Then the very short points of reply. First of all, my learned friend pointed to the fact that the claimant's pleading states that she doesn't know her husband's current status, and that, of course, makes sense in circumstances where the relationship is broken down. But that was irrelevant, because the relevant status is the status she had at the time that she was granted leave as his dependent. And so with respect, that doesn't take things anywhere. Secondly, my learned friend pointed to her witness statement. And it is fair to say that in her witness statement, she does refer to the fact that she wasn't clear about her status. She referred to her husband having transferred initially on a shorter project and then a longer project, which she understood would give rise to the ability to apply for leave to remain. But it is, I think, just important to note the chronology here, in that the claim was issued on the 23rd of September 2021. Permission was granted, and the detailed grounds and evidence on the Secretary's statement served by the 8th of March 2022. The claimant's witness statement then followed on the 31st of May 2022, and it was then in June 2022 that there was correspondence from the claimant in relation to the question about her status. So, whilst it's right that that was in her witness statement, it's not a case where the witness statement, as it were, formed part of the original claim documentation. And then the hearing itself was at the end of June 2022. But my Lord, other than that, there were no further particular points I wish to make, unless there's anything the court would like me to address you.
Can I just check if there's anything else? No, there's nothing else. Thank you both very much, and my thanks go to everyone who's contributed to the presentation of this case. We will reserve judgment in this case, and we will circulate our draft judgments in the usual way on a confidential basis in due course. As those of you who are familiar with the procedure will know, that is an opportunity not to re-argue the case, but to file any obvious factual corrections or typographical errors that need to be corrected. And I must emphasize that this court takes very seriously any breach of the confidential embargo of the judgment before it is finalized and handed down publicly. This court has said in a recent decision that will be taken very seriously and may in certain circumstances constitute a contempt of court. Is there anything else? Thank you very much.
All right.
See you.
It is just